Good evening, everyone, and welcome to our fifth Legal English series on contracts and cases in common law. My name is Jennifer Euler, and I'm the director of the Regional English Language Office for Russia with the U.S. Embassy in Moscow. It's my great pleasure to extend a wide welcome to all of you who might be students of law, practicing lawyers, people who are interested in law, or maybe even some English teachers who work with English for specific purposes and legal English. I understand we have 1,649 registered participants, and we're excited to extend this opportunity to a wide number of interested people in the community. We have excellent partners, so a special thank you to the Legal English Center and the expertise of Sofia Baranova, who has facilitated this project from its very beginning 2 years ago. And we have a wonderful specialist also lined up to work with you today, Danielle Capretti. Some of you may know her if you followed our earlier webinar series, but you'll get to know her in this series of 6 webinars. I'll introduce you to her here in a minute. This program is such a pleasure to conduct because it connects so many wonderful parts of our public diplomacy initiatives that are centered on bringing together people to understand the practices of everyday life, the profession of English teaching and law, and also language. Learning to handle the language, its nuances, and what it means in specific contexts is important for any professional, but particularly for lawyers and those who are working with the law. The U.S. Embassy in Moscow has many programs, activities, resources, and exchanges for learning English. Like this program, they're all free of charge. I encourage you to visit the U.S. Embassy website where you can learn about those opportunities and find links to more resources. This is one of many programs that we conduct that help to develop skills around English language teaching and English language learning. I would love to hear from you if you have an idea for another project or program or a resource need. So please reach out and know that our door is open and we welcome all of your input. Today is a special opportunity. As I mentioned, it's an anniversary. This is our 5th series on legal English. We've covered a lot of different topics, and this one will dive deeply into common law, particularly contracts and cases. I'm not a lawyer, so those things don't mean a lot to me, but I imagine they're very important. And those of you who work in this profession know that this is a unique opportunity to understand the side of law from the American perspective and to compare it with your own realities and perspectives in Russia. I hope that you will learn a lot from this series. You will take it seriously and grab every moment to participate, to ask questions, to take notes and come back to the vocabulary later, but mostly that you will enjoy the encounter, the ability to be with this community and to be with a great English language specialist. As I mentioned earlier, the facilitator for this series is Danielle Capretti. You're so lucky to work with her. She's lived and worked in 15 countries and specializes in the field of legal English. She's an honors graduate of the Syracuse University School of Law. She's worked with lawyers, judges, and civil servants in many different countries, including in Russia in a previous series that we hosted. Additionally, she was a lecturer at the University of Augsburg in Germany for 2 years, with primary responsibility for preparing students for a legal English certificate. As an English language fellow, which is another program through the Regional English Language Office in Croatia, she worked with that country's 4 major law schools to strengthen their law school curricula. She was also an English language fellow in Albania, where she was responsible for legal English training at the School of Magistrates and the University of Tirana Faculty of Law. Recently, she taught 2 sessions of the law pre-sessional for Swansea University and continues to work with private legal English clients through the International House London Executive Center. She has such broad experience and a great personality that will enrich this session in a way with not only knowledge, but I think a format that will engage and motivate you to keep learning. So Thank you very much. I'm going to give the floor to Danielle and just say to all of you, happy learning. Enjoy the program.
Very good evening, everyone. And we would like to welcome you to our series on legal English. And I'm going to speak a little bit about the logistics. My name is Sophia. I'm going to be the moderator of the series, facilitate, and I will help our virtual English language specialist, Daniel. And speaking about our logistics, we're going to have 6 webinars live, like we're doing right now. And you will be able to ask and answer questions. So we'll try to make it as interactive as possible. There are 2 ways how you can answer the questions. First, of course, you can answer the questions that Daniel is going to ask you, and she will ask you questions in comments on YouTube. You are very welcome to do it. Second option, those of you who got registered, you received a link to the presentation that you can see up on the screen, and you will see up on the screen, and you will be able to answer directly to Danielle if you join these presentations. So she will have the data from you and the names from you. So only she will be seeing the answers, and we will compare some of them. If you want to ask the questions, so you need to write them in comments on YouTube, or you can use our Telegram channel, and I will ask these questions to Daniel as we go, and also at the end of our webinar. So Daniel, I'm so glad to see you again on our project, because we've been already with Daniel in our series number 3, and we're so happy that you are back. So the floor is yours, Daniel. Daniel, go ahead.
Okay, so thank you so much, Sophia, and I'm delighted to be working with a group that I consider to be very learned and very curious about legal English. In this particular session, in this series of webinars, we're looking at one of the building blocks of legal English vocabulary, contracts. And we'll look at contracts in their most basic form, but also in the context of property and civil procedure. So I hope to be bringing a lot of new legal English vocabulary and concepts your way. So let's start off with our presentation today, which is Contract Vocabulary 1. And we're going to talk about contract formation in common law. But before we do so, you will see a little JD by my name, a JD. So we talked about it a year ago when I did my last series, and I'm wondering if anybody remembers what that JD stands for, and also how many years I had to study to get that JD. So I would love for our YouTube viewers to put some answers in the chat box. So what does a JD stand for, and how many years did I have to study to get that JD?
And actually, yes, Daniel, we already have some answers. And it's Juris Doctor, Jurisprudence Doctor, and Alex thinks that you studied 9 years to get it.
Okay. Well, they were very quick to answer.
Or 3 years. Yes. Excellent. Or 3 years.
Excellent.
3-4 years.
Okay. Any other guesses?
Yeah, so Juris Doctor, mostly 3 or 4 years. So from what I can see in our comments. So Antonina says 6 years. So Juris Doctor. So it's mostly 3 years, 4 years, and then yes, someone thinks that 6 or 9. So thank you very much, everyone, for being such active.
Yeah, that was quick. So yes, Juris Doctor. Okay, there's a lot of Latin which works itself into legal English, and that is the title for someone who has graduated law school, but only in the United States. They have different titles in the UK. I'm afraid nobody got the number exactly right. There were some of you that were close. I actually studied for 7 years. And this is because of a very important difference between our system and European systems, and even the English system, which is more like your system. In America, you cannot do law as a first degree. The idea behind this is that they want people to have a little bit of maturity before they do their law degree. So the youngest that you can do a law degree is about the age of 22, after you have done your first degree at university. So in this case, everybody has to do a 4-year degree at university, and then they go to law school. Sometimes the law school is the same university, is at the same university that the person got their bachelor's degree from, but sometimes it is different. So I had got my bachelor's degree. I received it from Dickinson College, and then I went on to do my law degree at Syracuse University. So that's something that's one difference that you might want to think about when you meet a common law lawyer, especially one from America. They have been educated for 7 years, and they are older when they start. The youngest lawyers are in their mid-20s when they start. Okay, let's move on to contract formation. So, Sophia, would our Russian audience need a bit of help with the word formation, or do you think they're fine with that?
I absolutely think that we need to have the explanation of it. So, so if you can do so, I would be more than happy. Yes,
okay. So, formation, a noun. It is the long form of the word form. Okay, and if you have a verb to form a contract, to make a contract. And today we're going to talk about the elements that we need to make a contract in American common law. Okay, so there's certain elements that you always have to have, and there's all sorts of vocabulary that relates to forming a contract. So before we start, though, I do want to thank Jennifer and Sophia for being so wonderful and putting this program together. This cannot happen without these two wonderful women. So if you see them anywhere, please thank them once again. And I also would like to know what your thoughts are about contract law. Now, you can write in the YouTube, you can write me personally through the link. And I see that Maria has already written a number of words. She gave me a very, very long list. So I would like to see your list. You can write them again in the YouTube, or you can write your answer on my presentation and then press the send button, and they will come directly to me. Again, Maria S., she has gotten a wonderful start, and she's even included some Latin terms. And yes, we do still use a lot of Latin in our contract law. They're trying to phase it out because some people don't understand it and they want to make contracts accessible to everyone. But yes, these are great ideas. I'm looking at things like force majeure, execute, undertake. So bravo, Maria. Let me hear some other suggestions. Anything happening on YouTube?
Oh, yes. And as I said, everyone, so you can have 2 channels of giving you answers. Either you can vote or you can answer through the link in the presentation. So only Daniel sees your answer. Speaking about YouTube, you have enormous amount of comments, Daniel. So the words are from Raphael: offer, acceptance, consideration, intention. Marusia: breach. Alia: boilerplate, annex, article. Raphael: tort, negligence. Anastasia: mutual assent, so agreement. Then Anastasia: consideration. Or Vladimir: obligation. Dmitry: draft, freedom of contract, mutual agreement from Elia. So Irina: legal capacity of parties. So act of God, Marusia, preamble, recitals, agreement of promise, licensed products, scope of contract, negotiation, transactions. Huge
It's a
amount of words.
contract explosion. Wow. Okay, and let's see, from me, I see Olga has given us the wonderful word consideration, right? And apologies if I'm not pronouncing your names correctly. Mutual assent. Tim has gone for enforceability, and these are all very sophisticated words. I'm seeing consideration is mentioned in a number of places, and that's a very difficult and important concept that we will discuss today. So thank you for your ideas. This is a great start to our time together today. Now, moving on. You thought I was going to be teaching you things, but now we're starting off. You need to teach me some things. So I would like to know where you're coming from in terms of what contracts are like in Russia. And the first thing I want to know, where is the law of contract? So this would be a YouTube or a Telegram answer. So where do we find the law of contract? I think I know the answer, but you'll be able to tell me something more specific. And how do we form a contract in Russia? Are there essential elements that if you don't have these elements, there is no contract? So I'd like to get some answers to those two questions via our wonderful and very, very chatty people and active people on YouTube.
Yes, and we're very grateful because I think for every teacher to see response and to see interest in the classes, this is such a joy, honestly. So, and I already have some answers. So speaking about where you find the law on contracts, so we have absolute unity on this. It's the Civil Code of the Russian Federation, and it deals with all the issues related to contracts. So Civil Code, we're a country with codified system. Is speaking about how well so there are some interesting answers. So speaking about how, so basically the contracting parties must be present. So and they draw up a contract, but I think you need to formulate or reformulate the question. So what do you mean under how? Like the necessary elements, or like
for example, does a contract have to be written in Russia? What elements, if you have a piece of paper and you're making a contract, what elements have to be there? What concepts? So maybe I'm assuming the Civil Code is going to tell me what I have to have to make a legal contract.
Okay, so and we already started to have the answers. So basically, Ivan and the others agrees that Civil Code deals on how one forms a contract. So the necessary elements are offer and acceptance. So these are what must be present. So also we have someone who says that together with Civil Code, United Nations Convention on Contracts for international sale of goods, if we speak about international type of contracts. So and mostly Civil Code, so offer and acceptance must be present, but elements depend on the kind of a contract.
Okay.
So some contracts can be regulated also by special laws like supply laws. So and the contracts can be oral, but it depends on the amount and the scope of the contract. So there is a certain limit in Russia. So and above a certain threshold, or it must be in writing.
Okay. That's very, very comprehensive. Now, with a system with a Civil Code, it's really easy. Unfortunately, in common law, it's a little bit more complex. It's a little bit more complex. And we don't have one code or one place where you find all the rules about contract. The ramification of this is that you can do a lot more with your contracts in common law than you can in civil law. When I have lived and worked in a civil law system, they had specific type of contracts. These are the things that have to be in every contract. In common law, as long as you satisfy the elements, you can contract about anything. And there are the rules are much looser. So there's a lot more that you can do. So the power to contract is much higher in terms of the individual parties having autonomy to choose their terms. And let's look at all of that. So if we look at the grand schema of things, contract law and common law has two major components. And I'm speaking about the United States here because it's slightly different in the UK. Sometimes they're similar and sometimes they're different. The first part is judge-made law, and that means cases. And notice I have starred judge-made law, and I have said that the second restatement of contracts is highly persuasive. Okay, now, if you have a really, really good memory, last year, this time, I did talk about something called a restatement in another webinar. So I'm wondering if anybody on YouTube can remember what a restatement. If you remember this, you get a star from me today.
Okay, so a question. So if someone can answer what restatement is, I think we need to give some time so we can go on and then we can ask.
Okay, so we'll go back to that. Now, another part of that equation is the Uniform Commercial Code, or the UCC. Now, Sophia, would the Uniform Commercial Code be a new concept for our Russian viewers, or is it something that they would have heard of before?
It depends, because we did speak about UCC in our previous series when we spoke about business law, legal English webinar series. But we do have a lot of viewers who are new, so if you could just like say a couple of words, that would be really appreciated.
Okay. Okay, so the Uniform Commercial Code was designed to be a model of good practice for sales contracts, okay, commercial contracts. So not a contract between two private people. This model was created because there were all these cases about contracts. So this model was created to standardize some sort of law about contracts. Now, notice that I have some states here from the US, and there are different names for the Uniform Commercial Code in these states. Now, what does that mean? That means that each state was entitled to adopt whatever part of the Uniform Commercial Code that they want, and also they were allowed to modify it because it was just a recommendation. So if you are selling things to Ohio, for example, you have to look and see what their Uniform Commercial Code is, because contracts law is not federal law. It's about all the 50 states having the right to do their own thing. So
can I ask a question, please? So yes. Uniform Commercial Code is actually uniform for the state, but not for the United States.
Okay, uniform is the original model code. Okay. We'll take a look at that. Each state adopted that code, but has the right to change it. Okay, so each state would adopt their own version of the code. So in my list, you see in New York, it's UCC. In Oklahoma, it's called Commercial Code. In Pennsylvania, they have adopted it, but they put it in different legislation. So it's a bit messy. However, this does say that there are some standards for contracts that are universally recognized in the US common law system for commercial goods. Now, those of you that have the presentation, you see there's a little finger there. If you click on that, that will take you to the website where you can explore all of the different commercial codes and have a look at those.
This is cool.
So let's go back to restatement. So do we have any ideas about a restatement?
Yes, well, we do have two answers. So one is from Tim, that the restatements are doctrinal comprehensions of the US legislation and regulations along with precedents on certain areas of the US law. And Ivan says that that's a product of American Law Institute. So
okay, thank you for taking a stab at that. Thank you for taking a stab at that. So with restatements, again, we're in common law. What they have tried to do is summarize all of the law to date, which is agreed upon, which is standard, which is a standard principle of contracts. Now, notice that it says highly persuasive. So this is not the law. You could go into a judge and say, the second restatement says this. The judge can say, no, this is a different case. So it is not mandatory. If it's mandatory, it's the legislature has written it, and this is what you must do because this is in what the legislature has written. With something that is a restatement is just a summary. It is a good summary. And most judges, if they see second restatement of contracts, they will respect the contractual principle that you're trying to argue, and it would be persuasive, but it is not mandatory. So remember, when we're talking about cases, they are persuasive. A judge can decide that the situation that they're dealing with is a completely new situation. And we will discuss this more in terms of hierarchy when we get to civil procedure, because it's all related. The biggest point is that there are a number of tenets which are accepted as, okay, this is what a contract is, but you have to go back to the cases and to the restatements to find them. It's not set out very nicely in a civil code as it is in Russia. So it's a little bit, I would even say messier and more complex.
And we start getting the questions about, so where to go first?
Where to go first? Okay. So where to go first? So let's actually move on, okay? And we're going to look at first the basic elements that are pretty much settled as to how every contract has to have these elements. Now, my question is, how many elements does a contract have to have? So when I studied contracts in law school, how many elements did I have to learn for my first year exam? So if you are on my presentation, please click and send. If you are on YouTube, write in the number that you think is correct.
Mm-hmm. So it is very interesting. So I have two options, honestly, myself.
Okay, that's fine.
Mm-hmm. So, okay. Well, actually, we start getting answers which are not on your presentation.
Oh, wow.
So
okay.
variety. Yes.
Okay. Variety is the spice of life. Fantastic.
Yes. So we do remember that we have a lot of lawyers here. So there are going to be a lot of opinions. So in my in the comments that I see, so we have a lot of people who vote for 2, for 6, 7, 4, 3. So mostly, so it is the 4, 5. So 4, 5. Someone even writes.
Yeah,
that,
and I see Omar has given me 4 to 5. And yes, if you're in the 4 to 5 range, and there's a reason why I'm saying 4 to 5, that's how many elements that would be considered to be the basic elements that every contract has to have in American common law, slightly different in British common law. So let's move on to these wonderful elements and have a look at case law. What do you think is the first element? Sophia, you mentioned this element previously. What do you think?
Oh yes, so and we have a lot of our viewers suggesting that it's either intention or offer. So
okay, yeah, and this is where you could really say that there are two elements here or one element, because you have to have an offer and you have to have an acceptance. Okay, so you can count them as one, you can count them as two. I'm very open to that. I think that is a either or. Now, in terms of discussing offer and acceptance in common law, I thought I would give you a look at the Uniform Commercial Code. And again, this is for commercial contracts. Again, you have looked at this in the last session. And I think there are some key elements that this section 2-206, points out in terms of offer and acceptance. And notice again, very lawyerly, unless otherwise unambiguously indicated by the language or the circumstances. Our first key word there is unambiguously. Sophia, will our viewers need a bit of help with that word?
Yes, ambiguous, ambiguity, unambiguous. Yes, if you could please clarify, because it's such an important word and people always forget it because it is horrible.
Yeah,
it sounds horrible.
Notice it is a negative. It's unambiguously. So it is a negative of ambiguous. Ambiguous means not clear. Unambiguous means clear or clearly indicated. And I would imagine that you would probably have the same principle in Russia. We need to clearly indicate our offer, what it is, and we clearly need to accept. If you don't have this clarity, then you do not have a contract.
Mm-hmm.
So this should be standard, and I think in all civil common law systems, there's no difficulty in understanding it. It has to be clear. Now, clarity can be in the form of writing, not necessarily, because we can have oral contracts in common law, and it's going to depend on all sorts of things: the jurisdiction, the amount, the parties, but in theory, you can have an oral contract as long as both parties are clear.
Mm-hmm.
Now, I'll explain the second one and then I think it's a good time to take a pause for questions. So those of you that are having some questions now, start to maybe think about those. So, an offer shall be construed as inviting acceptance. An offer must ask for acceptance in any manner and by any medium reasonable. And here's that wonderful word. We saw it in torts last year, reasonable man standard, and we're seeing it again in contracts. Now, this one is also important. If I give you an offer and then you accept it 5 years later, that would not be considered reasonable. Most likely, it would be elapsed. So we have to behave as a reasonable person. There is that standard of common law in making the offer and accepting the offer. And they both have to be clear. Those are two fundamental principles of offer and acceptance. And I wouldn't be surprised if you had something very similar in the Russian legal system.
Yes. So, and everyone who was writing about the elements of the Russian was explicit and were expressly stating that offer and acceptance always are the basic elements that always must be present.
Yes, yes. And, you know, if you are looking at this in common law, the question will be down to the individual circumstances. So the case law is coming from, did this person make an offer? Did this person accept the offer? I don't know. And this is sometimes where the judge is going to go in and look at everything using the reasonable person standard and the behavior of the parties. So this is where it gets interesting in common law, and you have case law. Do we have any questions at this point? It's a good time to pause.
So, yes, there is a question, and thank you very much, Irina. So Irina is asking, can advertisement be considered an offer? So, and also, who makes offers at auctions? So basically there are two questions.
Okay. So that's a really interesting question, Irina, and I have an activity just for us, just for you, and I hope everybody else will. So I'm going to save that because that's coming up, whether an advertisement is an offer, and that is actually the source of a lot of case law. In an auction, the auctioneer would make the offer, and then the person bidding would make the acceptance.
Mm-hmm.
In most cases, as a general rule.
Mm-hmm.
Okay. Any others, or can we move?
Yeah, there was actually one question, but I can save it for the end. It was speaking about whether you ever thought about getting an LLM, and maybe so it was the question that popped up somewhere. Mm-hmm.
Okay, so as an aside, LLMs are not important in America. They're important for foreign people who want to do their extra study in another country, and they are a little bit more important in Europe, but not necessarily for an American lawyer. There are very few that would have an LLM.
Mm-hmm.
Okay. Now, Sophia, I'm going to give you something and you're going to be very grateful. It is a carbolic smoke ball. And the carbolic smoke ball, you see this lovely lady has one, okay, and she's inhaling it, okay? And according to the carbolic smoke ball company, it's going to cure all of these terrible things. Anything that you have, a cold, a cough, loss of voice, throat deafness, influenza, hay fever, anything. It's if you use this ball, this carbolic smoke ball, this will cure your ills. It sounds like a pretty good deal.
Mm-hmm. So I honestly need to Google the word carbolic. I'm not aware of it, or so.
Yeah, it's an old-fashioned term. It's an old-fashioned term. I have no idea what that would be either. I'm assuming it's a mutation of the word carbon.
Yeah, something like this. Yes,
something like that. Something like that. Now, back to Irina's question. So, it was in the paper. This is in the paper. Is this an advertisement or is it an offer?
So we have a question. So everyone. So, and we actually already have one answer. So we have got several answers because one of our viewers said advertisement is an invitation to treat, not an offer. Anastasia says, yes, it is an offer. Irina says it's an advertisement. Also, we have others who say it's not an offer. So we don't have unity here in the answers.
Okay. And there was not unity when this series of circumstances happened. So there was a Mrs. Carhill, and she bought this carbolic smoke ball. Okay. She used it, and then she got the flu, sadly. Now, she looked at this advert and she said, I want my £100 reward. And in those days, £100 was a lot of money. And notice this is pounds, not dollars. And we'll talk about that. We'll talk about that. She said, I want my reward because I used this, I followed the directions, and then I still got sick. Okay, and I see £100. That's what I want. Now, should we give her her money?
That's a very good question. So according to this, so she did buy this product, yes? So,
yes. And this is way before consumer protection law was on the books. So she is. So
actually, we have.
Go ahead.
We have got very, very interesting answers. So Irina was very smart to say it's an advertisement with an offer. So, and we have one of our participants who says that it is invitation to treat. And if you choose one thing, it will become an offer. So we have very interesting logic in here. So,
okay.
But for now.
Okay. And I'm really curious about what the people in my presentations think. So I'd like to see some voting going on. So is it an advertisement or there is a clear offer made? So I'd like to see what my people working on my PowerPoint are going to say. So I'm very interested to see your comments. I'm going to point out something to everyone, and I do want to see if this changes your ideas. Does this change your ideas? So notice in this advertisement, by the way, advertisement is British English, advertisement is American English. We're working in the American systems today, so I will say advertisement. That to support this, sorry, go ahead.
No. So because I'm just reading, sorry, the comments, and we have quite interesting discussion going on here. So Ksenia says that the bank deposit made it an offer rather than an invitation to treat. Anastasia also says that they deposited money, so it was key action in this case to consider it an offer. So Natalia also says it's a commercial offer. Pablo says it's an offer. So, and Raphael says that it is an offer if it indicates a reward. So this is what our viewers are suggesting.
Okay. We have some very clever people. I'm not surprised. We have some very clever people today. So everything, if we look at this advert, everything may be up until the point in which they say £1,000 is deposited would be an advert or a puff. A puff. That's some of the language that they use. It's a puff. It's just merely, this is all not really meant. It's an invitation to treat, as somebody had said, an excellent use of the language there and the terminology. However, this £1,000 makes it a concrete offer with consideration. We'll discuss consideration a little bit later, but this is what makes it an offer. This £1,000. To accept the offer, all she had to do was to buy the carbolic smoke ball, and there was a contract. And remember, I'm not sure what happens in your system, but performing an act can be accepted. It's called a unilateral contract. So one person makes a promise, and then the other just does an action. There we performs an action. We had acceptance. So in this particular case, yes, there was a clear offer made. And sorry, carbolic smoke ball, but you have to pay Miss Carlil, sorry, her £100. Now, I have the case citation in the presentation. You see Carlil versus Carbolic Smoke Ball Company. What? It's from 1893. What? It's from the Queen's Bench. what is going on here? Why is this part of American law? It's really old and it's a British case. Can anybody speculate why?
For now, we'll just wait for the answer. And actually, while we are waiting for the answer, so why it is a part of American law and we actually look at it, although it's so outdated and it's from British, we have actually quite an interesting discussion because we have some viewers who disagree with you. They say that that is not an offer because there is no 100% guarantee from the manufacturer. That's why it is an advert.
Okay.
So, and or Irina says that, so yes, and we have some disagreement. So we have actually a discussion going parallel to our class right now.
Fantastic.
So because so we have some students who say that there is an object of advertising here, so it's absolutely an ad with an offer. So it's kind of interesting. So you actually threw like a bomb in among our students because
Good.
we have it's very controversial. It's very controversial.
This is what I want to see. I want to see everybody thinking and discussing. The judge on the Queen's bench regarded it as an offer. Now, if you want to see exactly what the judge said, again, there's that little hand in the presentation and you can click on the exact language of the case.
And Daniel,
and this is
we have the answer.
Sorry.
Yeah,
Okay,
sorry.
okay,
No,
yes.
sorry for interrupting you.
Go ahead,
We do have the answer. I'm just so happy we have the answer why it is a part of American law. So Amar says that because the American civil law system is pretty much based on the British one, which is in turn based on the ancient Roman one. So.
Okay. And a lot of the foundational principles of contract and property law were established by these key British cases. So this, in fact, is a case when I was studying contracts in my first year of law school, everybody has to take a big 1 year of contracts. This is one of the cases that we studied in order to understand offer and acceptance better. So it is a seminal case. Now, if you have, a contract about the internet or something that requires a modern interpretation, you would look at American law or you would look at British law specifically. But these foundational principles, we shared, American and British cases shared a lot of commonality, especially in the 1800s. British cases, generally, though, it doesn't go the other way. So there's very little American cases that influence British cases. However, in some respects, like the environment, American law is far ahead of British law. So sometimes there would be people here that would try to use an American precedent because there is no law in the UK on a certain subject. So it's in some cases, it goes the other way. But yes, I'm glad that we had lots of discussion, and this is what this is about. I recommend having a read of this case. The language is a bit old-fashioned, but this is something that every law student, I remember this from a long, long time ago, and it is one of the seminal cases that every law student is going to be learning about, even today. Okay, let's move on to the devil, consideration. And I find that civil lawyers have a huge problem with consideration because I don't think you have it in your system and they just can't. What is this? What is this? Am I correct, Sophia?
Yes, we don't. Well, we do have some phrase which is similar to the word consideration. So we have a concept which is close, but not that, not exactly what is meant over here. So consideration is much wider than what we mean. So, and it's very interesting to see for us what is it, because a lot of people would say that would translate, for example, if you have a phrase in consideration, like in exchange. So a lot of people consider consideration to be like subject of a contract or subject matter of a contract. So something that is an exchange.
Okay.
So, but it is bigger. It is
I like the word exchange. I think that's a good basis for looking at consideration. Does it have to be an exchange before the contract, or can it be an exchange after the contract?
You mean before the contract is signed or before the contract is performed?
Before the contract is performed or executed.
So, okay, let's just ask this question. So we need to rephrase it. So can you please just ask this again so our viewers can catch it?
Yes. Okay, consideration. Does it have to occur before the contract is executed, or does it occur after the contract is executed, or both, or does it depend on
executed? You mean like performed or completed? Yes, when it's like over. So, and we have already the answers. So we have the answers that before. So, and mostly these are all the answers.
Okay. It's a little bit messier. Sorry, it's a little bit messier. Okay. Because of the concept of performance or forbearance. Okay, performance or forbearance. Okay, so let's though look at the promise. Okay, so in a classic contract, I promise to give you $1,000 and you promise to give me your old car. Okay, one promise for another. That is what most contracts are, bilateral contracts, okay? Someone promises to do something, another person promises to do another thing, and there are two promises. Now, you can also have a promise and a performance, okay? So I'm going to give you $1,000, okay, if you clean my windows. Okay.
That would be cool.
Wouldn't
I
it?
could.
Okay, now let's look at forbearance. That's a that's a big, ugly word. Does anybody have any idea what forbearance would mean?
Okay, so let's just wait because we can give them a hint, but maybe someone can.
Maybe somebody knows this word, forbear,
yes.
to forbear.
Forbearance,
This
beautiful
terrible,
word,
terrible.
very academic word.
Yes, it's very academic.
And I'm just looking at the answers to your question. So yes, mostly everyone agrees that it should be before. So should be before the execution or completion. And Mikolai says that accepting party shall rely on promise. So consideration is both before and after the execution of the contract. And if speaking about forbearance, Lily says that it's not to do something. Anastasia says that it's action of refraining from exercising a legal right. Raphael says that prefix for means, well, it means something in advance, maybe. So,
okay. Exactly. Good. Bravo on forbearance. Yeah. If you forbear, you do not do something. Okay, you do not do something. So keep that in your mind. Keep that in your mind. Now, consideration can also be property. I give you £1,000 and I'm going to, and you're going to give me your new Apple computer, something like that. Okay. The most important point here is each party has to either promise, perform, forbear, or give property. The big thing about consideration is that, for example, if you have a gift, there is no consideration. So, Sophia, if I promise to give you 500 rubles on your birthday, and you say, Danielle, it's my birthday, where are my 500 rubles? Sorry, it was a gift. There was no consideration. So you cannot enforce that promise, even though you're worth it.
I have an interesting thought about it because I remember we discussed it once. So, and I had an interesting thought from one person who said, you know, maybe the happiness of giving a gift is consideration for the person who gives it. So, you know, there is some philosophy behind it. So some people, so can actually like a feeling be consideration? No, as I understand.
No, because you have not provided me any consideration. So I've given you a promise to pay. What is 500 rubles? How much is it? How much is that in dollars? Is that a lot?
Oh, it's like $5.
Okay, that's not a lot. Okay, so I have promised, but you have done nothing. So, and sometimes contracts are made, especially we're talking about a contract of duress. Somebody is forced to make a contract, and the other person has no obligations. These contracts have no consideration, and they are considered illegal. They're legal. They're not valid. Sorry, not illegal. They're not valid. They're not valid. Contracts of duress would be considered to be illegal, but we'll discuss that a little bit later today. Okay, and now let's go to our contract scenario 2. Okay, so Mr. Story promised his nephew $5,000, and that was a lot of money. This is 1890s again. Okay, it was a very important time for contract law. If his nephew would refrain from smoking, drinking, swearing, and gambling until the age of 21. The nephew turned 21 and then wrote to his uncle that he had fulfilled the agreement. And the nephew asked, okay, I've not done any of these things. Now I want my $5,000. Now, by this time, the uncle had passed away, so he'd written to the uncle's estate. Okay, now, shall we give the nephew his money, or should we not? Is it a gift, or does it amount to consideration? Because the nephew did nothing. He did nothing. Okay, he didn't do anything active here.
So
what do we think? What do we think?
Okay, everyone. So once again, you can vote via and then you will see your answers directly in your own system. And you have a link, the email, have the link in the first message, which is fixed in comment box on YouTube. Or you can just write your answer under the in the comments. So, and we start getting some answers. So, Daniel, and as usual, we have contradictions. So, one says that he's speaking about Russian law, no chance. So Marusia says that yes. So, according to the American law or British law, yes, he made good on his promise. So Anastasia says that it looks like consideration, but is there a contract from the very beginning? Okay. So Ilya says yes, it's forbearance. Nikita says yes. So Nikolai says yes, because it's forbearance, refraining from smoking. So, and someone says like it looks like forbearance, and there is a great comment. There is no proof that he didn't do it. Okay.
Okay. And you've all, and I see Oli has chosen yes, there was a contract. And there is some disagreement, though. There is some disagreement from my end too. Olga has said there's a contract. So, and the court said that there was, because of the classic case of forbearance. So he could have smoked, drank, sworn, and gambled, but he did not. So this counts as a offer. And in terms of the actual, is there an offer and acceptance? It is a unilateral contract. So someone promises to do something if someone performs or does not perform an act, rather than a bilateral contract where two people make promises. So in this particular case from 1891, and you see the case on the bottom, and then you can, again, if you have the presentation, you can click on it and then you can read. Now, let's have a look at the citation here. Does anybody know where this case would have come from if we look at the citation? And we'll do a little bit more about looking at citations when we do civil procedure, because that is a vocabulary in and of itself. So where was this case from? Any ideas? Those of you on YouTube?
So we haven't got the answer yet, but we have some interesting comments actually. Okay. So one of our viewers says that you cannot drink until you are 21, though. So you cannot refrain from exercising that right, as it is illegal. So
okay, that's an interesting point. That's an interesting point. I will. This was from 1891. I'm not sure at that time what the drinking age was. It would be interesting if it was. And there were some states also where the drinking age is 18. So okay. So in some cases there's an interesting comment. I do also want to go back to Ivan's comment. In Russia, no chance. And I want to know why there would be no chance for this in Russian law.
Okay, so Ivan, we will ask for your answer why it should be no chance. Maybe someone could also contribute. And everyone says that it's New York. It's okay. New York district. Exactly. So it's about citation.
Yeah, and in fact, it was a New York Court of Appeals because you have New York, and then NE was the Northeastern Reporter, and this is the site for an appeals case. So this was a case that went up one step in New York, and this is considered again to be a seminal case. I had to study that case in law school, and we also, when we didn't really know the principles, were like, no, he shouldn't get the money. He shouldn't get the money. But the judge decided yes. And again, if you want to read that case, just click on it, and you can see what the judge's reasoning was. But another seminal meaning important contract case. Okay, let's move on. Now, the next element is, it just makes sense, okay? So we have offer and acceptance, consideration, illegality. Okay, we can't make contracts for crimes, and I think this is a standard thing throughout any legal jurisdiction. It makes complete sense. And the last element, can anybody guess? Let's see. Can anybody guess what the last element is?
Mm-hmm.
Element actually, number 4/5.
We had actually quite a lot of elements that were written at the very beginning when we were discussing. So I'll just now scan through the chat. So, and they were actually so we have very interesting. So there is either intention or meeting of the minds, validity, legal capacity.
In terms of intention and meeting of the minds, that would be a subset of offer and acceptance. So that relates to the unambiguous, and that is a very important part of contracts. You know, we have to agree on the subject of the contract, the terms of contract. We both have to have the same understanding of it. The second one, so meeting of the minds, intention, there was one.
Yes. We have validity, a legal capacity.
Okay, so validity related to legality, and whoever said capacity, a star for capacity, a star for capacity. So the next element is capacity. Okay, so we have to have a contracting party who is, in the eyes of the law, able to make a contract. They have to be a minimum age. And let's discuss what a minimum age would be. So in Russia, what is the minimum age that one can have before they are they could be legally responsible for a contract.
So, and speaking about the legal age, so we have got kind of several options. So mostly Christina, Antonina say that it's 14, but and Pablo, so mostly everyone agrees on 14, but also we have got options for 18. So, but mostly everyone says it's 14, just because some may be limited already capacity.
Out of interest, in Russia, for example, establishing the minimum age for contract, would that be uniform throughout all of Russia, or would there be a scenario where in Vladivostok it would be one age, in Moscow it would be another age? Would that be, lawyers tell me, or would something like this, a minimum age, be standardized throughout Russia?
So, and some also comments before we answer, we wait for the answers, speaking about the whole Russia. So is that at 14 you can enter into minor contracts limited, and at 18 is a full capacity, and it's uniform for all Russia.
Okay.
So all, if I'm mistaken, 86 regions of Russia.
Okay. Thank you again for teaching me. I'm always delighted to learn more about another legal system. Okay. In this case, I would say the ideas about a minimum age are similar. There's some things that are standard throughout the world. It will depend on the jurisdiction. In the US, for New York, for example, which is we've been dealing with, the minimum age is 18. Okay, so 17-year-old cannot make a contract. Every state would be entitled to decide what the minimum age could be. It could be 14 in another state. You'd have to look at the law. Okay, and this would be something that would be dealt with in terms of statutory law. The second component of capacity is having a sound mind. Now, Sophia, does this concept of a sound mind need more discussion?
No, I don't. Well, we can discuss, although it sounds kind of understandable. So the person.
Okay. So, the idea of you have to be able to understand that you are making a contract. You have to be able to understand that you are making a contract and what the consequences of that are. Some of that is taken care of in terms of minimum age, but sound mind is another component. And in that respect, okay, which of the following would indicate that the contracting party did not have capacity?
So, drugged, drunk, Alzheimer's disease, dementia, comatose, all of the above. So, and everyone.
Do any of these words need explanation?
Well, probably not, but the only thing we need to understand, we need just to remind that drugged probably can be a lot of people in Russia. We can translate drug as like drugs which are illegal, like narcotics. And on the other thing, a person might think the drug is a medicine. So drug means both in this meaning, or only like someone is under narcotics, or it's like influence of medicine.
In this particular case, it would be under the effects of narcotics. If somebody is drugged, they are under the effects of drugs that could be legal or could be illegal.
Okay.
Because if you overdose on a legal drug, you could also be confused mentally.
Yes. So all of the answers are all of the above.
Okay.
So.
Okay. And some of this also bleeds into offer and acceptance. So, for example, if two people make a contract drunk, their minds don't meet either. So, for example, you might even say there was capacity, but because they're drunk, they've thought of different things, or they wrote the contract on a napkin, and there was no meeting of the mind. So, here, I think if we talk about where the controversy has come in, especially in common law jurisdictions, it's now centering on Alzheimer's disease and dementia. You have these old millionaires, men and women, that leave money to a much younger spouse, and then they die, and then the family says, no, they had Alzheimer's, they had dementia, they weren't doing the right thing. That's where all of the controversy is coming about capacity now. So this has really become what we say a hot button issue recently, because of these situations with people leaving a lot of money to the nurse or their friend, and then the family fights back and say, no, there was not capacity in this situation. And in the case of a will does have contractual elements to it, because you are, the executor of the will has to carry out the wishes of the decedent. Okay, now we have our elements. I think now is the time to stop and ask if there are any questions before we head to the summary. So this is where you get your final questions is before we summarize what we've discussed today.
And everyone, so you can please write any questions you have. So, and there is one question. Which is actually in relation to corporate law. So I received it from Telegram. So if a person sets up a company, is it considered to be a contract in between this person and the government or not?
No, that's an interesting question. Not in our jurisdiction. Now, for example, if you set up a company, and I know more about the UK law than the American law on this one, so I'm going to speak about UK law. If you set up a company in the UK, you have to register the company with Companies House, and there are certain reporting requirements, but it's not considered to be necessarily a contractual relationship between a person and the government. Very interesting. However, there are certain requirements that a company must meet. So if a company does not meet those requirements, it would be in breach of its obligations under Companies House. But it's not really, this is more a corporate law thing than actually a contracts issue. But that's a very interesting question. Thank you.
Yes, because we have even continuation over here from Ivan, actually, so on Telegram, who says that, but can the taxes that a company pay be considered consideration, because the government in return provides limited protection for like limited liability, so it's not consideration because there is some exchange.
Okay, that's a really fascinating point. Ivan, you're a great thinker. I think that's like a legal philosophy debate. But what I like about it is that you're flexing your legal muscles on these things, and this is audience having a very high level of philosophical understanding of the concepts. So, Ivan, you never disappoint me.
So, and we have another question. So, if we are talking about a simple contract, for example, to buy food at a grocery store, can a person under 18 years old of age in New York enter into such a contract? It's Ilya asking on.
Okay, that's quite a fascinating question. Now, that would be a question of consumer law. And there was a time when we had no consumer law. And I don't know how this evolved in Russia, but before sort of like the 1920s, there was no consumer law. It was buyer beware. So, and if you bought something and it poisoned you, okay, those are the breaks. Now we have consumer law. So what you would have to do, this would be regulated by the consumer law of the states which are talking about sales of goods. So there I would have to go to an individual state and look at their statutes in terms of what they say. But that's a really fascinating proposition.
Okay, so thank you very much. Another question is from Nikolai. How is forbearance? So I think Nikolai might have been inspired by Ivan and his question about the legal entity. So how is forbearance treated in terms of corporate taxes in UAB for free acquisition of A's product? Is it valid?
How is forbearance treated in terms of, what was the remaining bit of that?
Corporate taxes in US.
Okay, that is tax law. Forbearance is a contract law.
We cannot mix it.
I think we'd have to look at the tax law in that respect. There are some things that are very tied to statutes these days, tax law, consumer law, and you cannot, it's a separate area of law. And I know for a civil lawyer, the idea that there's all these separate areas of law, there's no one code, it's a bit strange. And for us as common law lawyers, the fact that there is one code is a bit strange, because we, as common law lawyers, don't feel that the code has all of the answers.
Okay, so then Nikolai, I think you need to rephrase your second question about like free acquisition, like do you mean purchase? So just sorry, some questions. There is also another question, so maybe also needs to be rephrased. Which circumstances fall under the term of unconscious, when someone is unconscious, unconscionability? So
okay, so now I think you're talking about unconscionability, and that is a separate concept from being unconscious. We talk about certain unconscionability, certain unconscionable circumstances, and these are contracts that are what's a good word for it, that are almost disgusting or reprehensible. Okay, for example, there's a little old lady and a builder comes to her and says, if you pay me 3,000 pounds, I'll clean your windows. And the lady says, okay. That would be considered an unconscionable contract, because he's taking advantage of this old woman who may have dementia. So that is one type of an unconscionable contract. These are contracts that are so revolting or disgusting that the state says, no, this is not appropriate. Some of this has been taken over by legislation in terms of consumer law. Like, you know, the market cannot sell, if it had food that was poisoned, it's not allowed to sell it, and it would be punished by statute. But any contract that no reasonable person would consider to be a fair contract. So you often, in a case of duress, when somebody is forcing you to sign a contract, I mean, there are a lot of people, especially in the UK, that would joke that a lot of the mobile telephone contracts, the contracts for cell phones, are unconscionable because you can't read them, and every 5 minutes the price is going up. So a lot of people would say that, but that's a very excellent term to discuss it. Thank you for bringing it up. Okay, let's move into our close here. And I want you to think about, you can do it on my presentation or you can do it on YouTube, the most memorable word from this session. So what really sort of struck you as this is fascinating? I hope something did.
Yes. And while we're waiting for the answers, and we will ask everyone to write just the word, we did have actually one sort of question about your own experience. It's a funny question about like whether you ever had in your own practice some very weird contract or some memorable situation that was related to contracts. So maybe something that was like unusual. So something.
Hey, let me ponder that. Let me ponder.
Yes, of course. And also there is one more question while we're waiting for the answers. So which is, I think, can be easier to answer. From Anastasia, can you clarify, please, the concept of reasonable person? I do understand that it is a hypothetical person and that the judges use it in order to say whether there was a contract or not. So, but still, like reasonable. So, is it like fixed? So the ideas.
Okay, and you gave, sorry, the name of it was a lady.
Anastasia. Yes, Anastasia.
Anastasia. Okay, you gave a perfect definition of a reasonable person. It is a fluid concept. Okay, it is a concept that changes. And what the judge will do, or the jury will do in this case, is look at the circumstances and think about what a normal person would decide or think about the situation. So it is very, very related to what would be normal and reasonable in that situation. And I know that's, again, it's hard to say, but you really, with a reasonable person, you really have to look at the individual facts of the individual case and say, okay, this person acted reasonably, or this is what is reasonable in the circumstances. And we'll have a look at that in terms of things like damages.
Okay. And we have very interesting choice of the words in our comments that were memorable, from this class. A lot of people, so Karina, Ivan, Alia, so, and Anastasia. So Vladimir would say that it's forbearance or forbearance. So
forbearance.
Yes, Ilya. So forbearance, and Ilya says that it wins. So then the word consideration, the second place I would say would go for consideration. And then there were some sweet things such unconscious. Oh my goodness!
Unconscionability. That yes. Unconscionability. That's a seven-syllable word.
Yes. So then also duress and carbolic.
Yes. So, they don't sell those in England anymore, by the way.
Yes. So, and we do have, we have some quite funny also questions that are popping up. And
let me see how much time we have, because I need to get through some things, and then if we have a bit of time, we'll answer questions that have to do with contracts. Okay. So I just, again, if you have the presentation, I've included some links in. If you're interested in reading a bit more about contracts, they're good links and links that I would recommend. So the first one is a link to a website that is set up and run by Cornell, which is a very reputed law university in New York, in Ithaca. When I did my bar exam, I studied at Cornell to study for the bar exam. And this has a lot of nice definitions, links to other sites. So again, if you go and you press this button here, you can link up to that, and it'll give you some nice plain definitions of all sorts of concepts. And it has the UCC and a number of things in not only contract law, but you can look at other areas of law. The second thing with a link is a YouTube, okay, which has been created. It's a series of YouTube videos created by Harvard professor Charles Fried. And he's talking about contracts on a very basic level. you know, what is a contract? Why do we have contracts? And this is a nice introduction to contracts from a very, very prestigious and learned academic, but the language is nice and basic, and it's a very approachable way to deal with contracts. Okay, I think we have time for maybe one question before we finish off today. Is there a question that is related to contracts?
Yes, so we have got two questions which are related to contracts. Both of them speak about situations. So for example, can you please decide whether what is your opinion in this situation? I bought an annual subscription at a gym, but it closed because of COVID. Was it an unjust enrichment or a force majeure on the gym's side?
Wow. Okay. Very, very beautifully phrased question. I would want to argue unjust enrichment, quite frankly. But I think it would probably be force majeure. Sadly.
Okay. So, and another very, I think everyone was just amazed, not amazed, by interested in this drunk situation. So another situation, the already drunk client ordered different dishes in a cafe, but doesn't want to pay for them after eating. Did he have capacity in this case? So can he argue like I was not capable?
Yeah, I didn't have capacity there.
That's a quite interesting story.
I think we would have to go again to consumer protection law on that one.
Mm-hmm. So it's another story. It's consumer. Yeah. Okay. So
yeah. So sometimes we do have to go to the statutes on these things. But
yes.
What I like is people are thinking, people are using the vocabulary, and this is what we want to do. Okay, so let's look ahead because we will be together in 2 weeks' time. And in 2 weeks, we're going to be looking at breach and remedy. So today was forming a contract. What happens if the contract goes sour, we would say in English, and what type of money can you get? So things get interesting with breach and remedy, and there's a lot of case law and a lot of ridiculous. I can tell you, somebody said, have you ever encountered a very strange contract? I think next in 2 weeks' time you'll see a very, very strange contract. I never saw anything. I was working mostly in property law, and we had the standard contracts, you know, rental contracts. So it was nothing sort of outrageous. But there are some ones, especially that are seminal cases that have quite outrageous sets of facts. So all that remains is to thank you for your participation on Telegram, on YouTube, on working directly through my presentation. It was a delight. I always know that there's going to be a very high level, sophisticated discussion when I work with Russian lawyers, teachers, and students. And it's always very stimulating for me. And I hope I see you again in 2 weeks' time.
Yes, and I would like to thank you so much, Daniel, on behalf of our team, on behalf of our participants. We have so many thanks in our comments on YouTube, so I will send you the link so you can read everything because it is in English. And everyone, we really value your contributions. So, and Daniel, you are a star, and we're so grateful to the Regional English Language Office that we have you. Thank you so much. And our journey has just begun. We have got 5 more classes, webinars ahead. So, and everyone, tomorrow we will send you the link, those of you who are, so you will have it, and also we'll send you the presentation. And then after some time, we will have some of the vocabulary translated also. It will be always available to you even after our project is over, and you're always very welcome to rewatch and to go deeper into the links. And thank you very much, Daniel, that you included the links to so many cases, because it means that we can go deeper into the contracts and cases and prepare for the next class. So everyone, thank you so much. Have a good night. And we were so glad to see you, and see you in 2 weeks. Bye.
Thank you. Bye-bye.
Bye, everyone. Bye.